does one respond to the ongoing dispute which is going on between the legislature and the judiciary? BJP's MP Nishikant Dubey is arguing that the Supreme Court has crossed its Lakshman Rekha by trying to give an advice to the president when it comes to how much time can the president or the lieutenant governor, a full-fledged governor of a full-fledged state, can really hold on a law which has been passed by that particular state cabinet. With me, the man who retired as one of the foremost judicial officers of our times, one of the foremost judicial minds of our times, retired Supreme Court Judge, Justice Katju. Always a pleasure to have you with us here on the Squirrels, sir. Welcome.
Pleasure.
Let me straight away first begin by asking you, sir. I've been looking at your commentary, and you seem to be in agreement with the view which is being echoed by Nishikant Dubey and even the Vice President, that the Supreme Court has crossed its Lakshman Rekha, specifically in the Tamil Nadu case. Why do you agree with the politicians and not with your own class, sir?
See, first of all, I must tell you, I'm not a political man. I'm neither pro-BJP nor anti-BJP. I'm a purely legal man. Now, in our constitution, there's broad separation of powers between the three organs of the state, that is legislature, executive, and judicial. And one organ should not encroach into the domain of another organ. Otherwise, there will be chaos. Now, what has been done in this judgment of the Supreme Court in state of Tamil Nadu versus Governor of Tamil Nadu is that the Supreme Court has encroached into the domain of Parliament.
How, sir? Is the Supreme Court giving relief to the common citizen? Is the Supreme Court giving relief to the political class, or is the Supreme Court, as you're saying, intruding into the terrain of politics?
First, I must explain to you the legal position. Then I will come to this question. See, what the Supreme Court has done in this case, it has, for instance, fixed time limits for the president and governor to give its decision about assent or not, when there is no such time limit fixed in the Constitution. So therefore, the Supreme Court has amended the Constitution. It is fixing time limit. It is in Articles 200 and 201. They have added that you must decide within this period, which is not mentioned in the Constitution. And amending the Constitution is the power of Parliament under Article 368. It is not the power of the Supreme Court to amend the Constitution. So fixing limit, they have crossed their limits. Secondly, by saying that there is implied assent of the governor if the state legislature reiterates its the bill. Again, there is no provision in the Constitution of implied assent. They get it. Again, it tantamounts to amending the Constitution, that if the bill is returned by the governor, but the state legislature repeats it.
But sir, again, if I may hold you for a moment, and sorry to interrupt you, but isn't one of the principal jobs of the judiciary, of the Supreme Court, and certainly of the Chief Justice, is to keep interpreting the Constitution as per the evolving democratic situation? Now, there is a democratic challenge in our country, which is that governors, like we have seen in the case of Tamil Nadu, have acted as stooges of the central government. So, should the Supreme Court not create a safety valve, much like what the Supreme Court has attempted to do, say, in the PMLA cases, by inserting a clause which gives people some relief and protects them if the central government was to act in a very partisan manner?
Now you permit me to complete what I was saying, then I will answer this question. But you
sure.
To keep me, I will not be able to complete.
No, sure, sir. Sure.
First of all, I'm on this question that it is not for the Supreme Court to amend the Constitution. It is for Parliament under Article 368 to amend the Constitution. By saying that if the state legislature repeats a bill which had been sent back once by the governor, there will be implied assent. Now, again, there is no such provision for any implied assent it has to be specific. The governor has to give assent by his order. It can't be implied. You see, take for example, the Supreme Court had said that if the Supreme Court Collegium repeats a name which had been recommended for appointment of judge of Supreme Court or High Court, once the government can return it, but if the second time the Supreme Court Collegium repeats the name, appointment must be made. But there are a large number of such cases where the Supreme Court Collegium has reiterated the name, but still the government has not appointed. Can it be said that by implication that there is implied appointment? So let the Chief Justice of India give them oath, although the President has not signed their warrant of appointment. By the logic, you will have to say that there is implied when the Supreme Court Collegium is repeating it, and the judgment is that if it repeats, then the appointment must be made. And if the government is not appointing, then there will be implied assent. Again, you are amending the Constitution.
Okay.
This Article 142, which they have used, is not a Brahmastra that you can do anything by Article 142. Why not the Supreme Court say that the government is not performing and not doing its duty properly, so we are taking over the function of the government? Or the Parliament is not doing its duties properly, so we are taking over the function of Parliament because they are not functioning properly. If you say that, then the Parliament and the government will say, all right, you judges are also not doing your job properly. You are taking 25 years to decide a case finally by appeal, after appeal and second appeal. It takes years and years, sometimes decades to decide a case. Finally, you are not doing your job, and there's so much corruption in judiciary. So you are not doing your job properly, you judges. So we are taking over the function of judiciary. The same can be as it is said that what is sauce for the goose is sauce for the gander. If the judges say that since the government and Parliament are not doing their job properly, we are taking over their functions, we are going to amend the Constitution, then the reverse can also be said by Parliament
But here, I take your point on a point of logic, Justice Katju. On a point of logic, on a point of law, you're right. But again on the point of law, if you have a situation which exists as of today, for the last 2 years, the Delhi Lieutenant Governor was on the warpath with an elected government in the state of Delhi, and look at what happened. In Tamil Nadu, the governor there, Mr. C.T. Ravi, has converted it into a fine art. If a union cabinet and elected government is consistently passing laws and he refuses to give his assent, and if the elected state government goes to the Supreme Court, are you basically saying if there is a conflict between, let's say, the institution of the governor and the institution of an elected government, the Supreme Court is not the right place to settle this conflict? Is that the point to understand?
Yes, that is what I'm saying, and let me elaborate on that. See, it is true that ever since Indira Gandhi became Prime Minister, the governors have been puppets of the central government. You would remember from the time of Indira Gandhi, she sacked, through the governor, she sacked N.T. Rama Rao, Chief Minister of Madhya Pradesh, because he was not towing her line, and other governors she was sacking. So, same BJP is doing. And it is true that governors are not behaving properly. That is correct. That they are holding on to bills for long periods, which is improper. I totally agree. But the point is, what is the solution to this problem? And my respectful submission is the solution is not for the judiciary to amend the Constitution. That is not the solution. The solution is not. You see, judiciary does not have a magic wand that every problem in the country judiciary can solve. There are many problems the judiciary cannot solve, and this is one of them. This problem can be solved by the political process or some other process. It can't be solved by judicial process. This, I agree. This is improper for governors to hold on to bills passed by legislature for years and years. Correct. I agree. This was improper. But what is the solution? How do you fix the problem? Problem can't be fixed by judiciary. Everything can't be, you assume that judges are gods. They can do everything they like. They can solve all problems. They can amend the Constitution. Why not then the judges say that, see, the government is not functioning properly?
The result will be bad. Okay.